Jade. Uh-oh. Uh-oh. I know that song. The last song was a new song, but I know this song. This is the song we start the show on. Yep. Who needs a timer? Nobody needs a timer. Timers are jokes. Ladies and gentlemen, how's everybody doing? It's Saturday. We have court cases to watch. We have some interesting court cases to watch. I don't know who has seen it, but Judge Ricke had an absolute bear of a sentencing yesterday. You may have seen it, you may not. It's nuts. The lady is extremely upset. You're gonna get to see all of it. Not terribly long. It's excruciatingly interesting and very much cringeworthy. So we're gonna do the Ricke first. Then we're going to move on to Judge Simpson, We got some Judge Simpson's PCC docket from Thursday. It's actually, it's not just like a whole block. It's kind of cherry picked things from the PCC docket. You might have seen a couple of things from that docket that have been making the rounds, but I haven't seen all of that, so I threw those in for myself more than anything else. And we're going to end it off, ladies and gentlemen. I just want to throw this out there. We're ending it off with Fleischer, you know, but it's not just Friday Fleischer, ladies and gentlemen. It's not just Friday Fleischer. It's Fleischer from Monday, Tuesday, Wednesday, Thursday. We're gonna look at Fleischer's whole wardrobe for the week. It's different cases. It's not just a stream of what's going on, but we're gonna get to look at almost everything that he wore to court all week long, because you know that's what really makes the world go round, right? Well, it is for today. That's what we're doing. That's my plan. It's a long one, and we're going to go ahead and get started with it. Ladies and gentlemen, thank you for coming out. I am your Lone Wolf Oozle. Welcome to the Weekend Review Court Gallery Live. Let's watch some court, shall we? Now, why is that like that?
Versus Patricia Ann Turpin. It's case number 2023 CR 486. Amber Norris appearing for the state of Kansas. James Watts is defense counsel. Defendant Patricia Ann Turpin now appears at the court security Zoom location at the Judicial Center. Ms. Turpin, you were late to your sentencing?
I was in the other building. I didn't know which building to go to, and I ended up in the other building. That's why I was late.
All right. I don't think there's been court held in that building for 21 years.
I've never been to court here, ever. I had no idea.
Now. This matter comes before the court at this time for sentencing. Docket notes from June 18th indicate that the defendant pled guilty to count 3, computer crime, a level 8 felony. A pre-sentence report was ordered. Sentencing originally set for August the 12th, subsequently rescheduled to today's date. This court has received an updated pre-sentence report compiled by Ryan Smith, pre-sentence investigator, who is part of this meeting. I trust each attorney has received the updated report, and I'll ask the state's attorney first. Is there any objection to the criminal history as stated in the report?
I did receive the update, Your Honor, and no objection.
Any objection to criminal history by the defense here, Mr. Watts? Mr. Watts? You're muted.
Your Honor, no objection to the criminal history score.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score H, and the court will proceed further accordingly. Ms. Norris, do you know of any legal reason why sentence should not be pronounced in the Turpin case here this afternoon?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, sir.
Ms. Turpin, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing?
No, sir.
Court proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Mr. Watts?
No, sir.
Very well. Are there any victims or members of a victim's family who desires to address the court in relation to this sentencing? Who is Deborah's iPhone? Or Jacqueline Green?
Your Honor, Jacqueline Green is the victim witness coordinator in the office.
Okay, all right, fair enough. And there's no family members with her?
Not that I'm aware of. And Your Honor, I'm not sure who Deborah's iPhone is.
All right. Is there someone whose screen name is Deborah's iPhone who wishes to address the court in relation to this Turpin sentencing? I would just like to have a yes or a no.
No, I do not need to address. This is Deborah, victim's
Okay.
daughter.
Okay, did you wish to address the court?
No, thank you.
All right, thank you. At this time, then, the court will ask for recommendations from counsel regarding an appropriate sentence for Ms. Turpin, beginning with Amber Norris on behalf of the state.
Your Honor, state would be recommending for the felony crime of computer crime. The court follow the presumption and assign defendant to 9 months in the Department of Corrections. Defendant would be able to earn 20% good time credit and would be subject to 12 months post-release. Defendant has earned 2 days of jail time credit. And Your Honor, this is a presumptive probation matter based on the crime and defendant's criminal history. So I ask the court assign her to 18 months community corrections probation with all standard and PSI recommended probation conditions, including a drug evaluation, no contact, and Your Honor, this is a community corrections case, so the court will need to assess standard probation and costs of the case, but then also the community corrections fee. There is a $200 DNA database fee. There is restitution in the amount of $1,305.44. Some of that goes to the victim's family and some of it goes to the bank. We'll make sure that the dollar amounts are specifically set out in the journal entry. Mr. Watts is appointed, so the court will need to address court-appointed attorney's fees and the bids application fee. And Your Honor, I don't think I have any further recommendations for the court at this time.
Very well, Ms. Norris. Mr. Watts, your recommendations regarding an appropriate sentence?
Thank you, Your Honor. Your Honor, we join the state's recommendation. They are in keeping with the plea agreement. I believe we join the recommendation of the mitigated 9 months with the post-release and probation durations and good time credits as noted. We likewise have no objection to the restitution that is set out in the PSI. I don't know that I have a whole lot else to add, Your Honor. Thank you.
Your fees and the representation of this client?
This is billed at $1,000 to bids. Or will
Thank
be.
you. At this time, the court will address the defendant, Patricia Turpin, personally and ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to present to the court. Ms. Turpin?
I just want to apologize to the victim's daughter. I'm very sorry for what I did, and
Okay.
I really just want to say sorry to her.
Any other statements for the court, Ms. Turpin?
No.
Very well. Court will pronounce sentence in this case at this time. Court hereby establishes count 3 as the base sentence in the case for the offense of computer crime, a severity level 8, non-drug, non-person felony, in which the defendant has a criminal history score of H, thus placing her in grid box 8H. Court hereby sentences the defendant to a term of 9 months in the custody of the Secretary of Corrections, the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed on that count. Court does note that in grid box 8H, this would be a presumptive probation case under Kansas law. There does not appear to be a special rule application here or a motion for departure to disturb that presumption. And the court will grant the defendant 18 months of initial probation term to be supervised by community corrections. Community corrections supervision is deemed appropriate due to the high risk score on the risk needs assessment that was conducted in this case. Conditions of that probation will be to report to an officer as directed, observe all laws, obtain a substance abuse evaluation within 45 days of today's date and abide by the recommendations of that evaluation. She shall not possess or consume alcohol or illegal drugs while on probation. At her ISO's request and at her own expense, submit to random breath, blood, and urinalysis testing, perform any community service work pursuant to any program requirements, gain and maintain employment successfully throughout her probationary term, notify her ISO of any change in employment status, residence, telephone number, or email address within 48 hours of any such change happening, have no contact with the victim in this case or members of the victim's immediate family. She shall submit her DNA to the KBI databank and be responsible for the $200 cost of the test, abide by any curfew or travel restrictions imposed by her officer, follow all standard conditions of probation, not have in her possession firearms or dangerous weapons, and avoid disreputable characters and places. The defendant shall also make monthly payments on her obligations owed to the court, which would include a felony docket fee, felony probation fee, community corrections fee, the $200 DNA fee, and a bids application fee of $100. Attorney fees are waived, as the court will also be ordering this defendant to pay $1,305.44 in restitution to the victims in the case, as their interest may appear. Or again, will require $200 a month minimum, starting in a month to be determined by the court. Ms. Turpin, there's one other order that the court wishes to consider in this case. This court, unfortunately, has to see many cases where vulnerable people are exploited by others. I wish it was not so prevalent. However, this needs to stop. You are not new to the court system. You have, I believe, 3 prior property crime offenses on your record. So you're not new to this, and yet you exploited this helpless woman who was the victim in this case. And the court does have discretion, despite the fact that the legislature has determined you're not a prison case, that the court can impose up to 60 days in the county jail as a condition of probation. And that's exactly what the court's going to do here, Ms. Turpin.
Please don't.
The court is going to order you to serve 58 days more because you've got 2 days of jail time credit against that sentence.
Can we schedule it?
Starting immediately.
Oh, please don't do
Ms.
this.
Turpin, you are an incredibly poor risk.
I've never done this to anybody
don't
before.
talk over me. Don't talk over me. You're an extremely poor risk to show up in jail on any type of schedule, because
I promise I will.
You couldn't even make your sentencing on time today. Further, last time you were
other
directed
building
to
I've never
appear
been through
at the
before.
Judicial Center and you didn't. Look, we're not going to talk over each
I went
other.
to the other building.
I've made my ruling. You're not going to cry your way out of it.
Please.
All right.
I got my
Yeah.
grandkids outside.
All right. Are you done, Ms. Turpin, so that I can complete your sentencing? Again, the court has announced 2 days of jail time credit. At some point in the future, Ms. Turpin, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any question about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, defendants have a right to appeal their conviction to an appellate court having jurisdiction. And if defendants are unable to pay the cost of an appeal, they may ask the court to appoint a lawyer to represent them on appeal and that they be supplied with the transcript of trial court proceedings. Pursuant to KSA 22-3608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you, the defendant, at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Ms. Norris, I wanted to ask you, of all of the financial assessments you were asking the court to impose, has the court covered all of those?
Yes, Your Honor, I believe so.
All right. Mr. Watts, is there anything further from the defense side that the court still needs to address?
I don't believe so, Your Honor. Thank you.
All right. The court is going to order Patricia Turpin into the immediate custody of the Butler County Sheriff's
Please,
Representative
Judge, please, my
until her
grand.
custody can be transferred to the Butler County Jail to serve out 58 more days.
Please don't do
And Judge, what month did you want the payments to start?
Yes, we do need to come back to that. In light of the fact that she's going to be incarcerated essentially through September and October, of course, not realistically going to expect her to make payments during those months. So the court will start her payment obligation as earlier announced for the calendar month of November of 2024 and each
I have one
subsequent month
kid too. Please don't.
until her obligations are paid in full. All right. I think the sentencing proceeding is concluded at this point. Mr. Smith, thank you for your work on the case and your appearance here today, Ms. Toronis. Ms. Toronis, she's a little bit emotional right now. Do you still want to have a session with her?
Yeah, I'd like to try if I could, please, Your Honor.
All right. So I'm going to go ahead and recess this proceeding. Ms. Turpin should stay. I'll just direct court security. She needs to make contact with her ISO so she knows what to do when she gets out of jail.
Please, Judge, please.
All right.
Let me schedule this jail time.
If there's
Please.
nothing further, the Turpin matter will be in recess at this time, and we can conclude the record and leave the Zoom meeting open for the ISO.
So yeah, ladies and gentlemen, that's how we start the show off right there. How do you like that? That's the first case. So for anybody who didn't really understand, I saw Mom out there was asking questions. Her sentence, her overall sentence was the 9 months. Like she has that 9 months to do in jail, but they probated that and gave her 18 months probation. So honestly, she's facing more penalty time with the probation. She has 18 double time, right? As a condition of that probation, though, she must immediately serve 60 days starting right this moment. So do not pass go, do not collect $200, go directly to jail 2 days, serve 60 days. Then when you get out, you still have the rest of that 18 months ahead of you. And if you mess anything else up in the next 18 months, anything at all, if you jaywalk and you look at a police officer wrong, or maybe just give somebody a bad feeling, you go to jail for 9 months. That's pretty much how it works out. It's actually a pretty stiff sentence. Probation is not easy. So, that was Judge Ricke. Gonna move right on down to right down. What am I saying down? Moving over to Michigan, Judge Simpson. This is just as good as the last one. Dig in, shall we?
Court calls case People versus Jonathan Lilly.
Deborah Schloss on behalf of the defendant, Mr. Lilly, who is approaching.
Your name, sir?
Jonathan Lilly.
Thank you. What are we doing?
So, Your Honor, my client had a no bond. He had a warrant for his arrest. We had him arraigned. You set no bond.
I did.
And Your Honor, I'm asking you to consider changing that. The reason you set a no bond is that he did not test for a number of days. And the reason for that, it was a complete misunderstanding on his part. And as soon as he spoke with me about it, he tried to correct the situation. He believed that once he was on the supervision of community corrections or pretrial services, that he did not have to test any further. He was
Excuse me? Say that again.
Basically, the whole situation is when I signed that blue form, nobody explained to me what the form meant. So I took an assumption of thinking that I didn't have to do that and I was going to get parole.
No.
Yeah.
July 9th, he tested positive for THC. July 10th, tested negative on an ETG and PBT. The 15th of July, he tested again and was positive. On the 17th of July, negative, tested, negative, tested. 23rd, negative. But all those points he takes tests. Starting in August, he just doesn't test.
Right, and that's, Your Honor, because he misunderstood. It's in terms of the positive, but
What changed in August?
It was just a simple fact that I thought that form meant I did not have to come in. Yes, it was my fault. I should have asked.
What
more
form?
questions. It's a blue form that basically is stating, I thought they was gonna give me a parole agent, and it asked if I was going through any type of care, through any agency for the drug testing.
And Your Honor, for the record,
That makes no sense.
for the record, Your Honor, we had not discussed this. The minute that I learned that this was going on, I did contact Mr. Lilly. He really did believe that, despite the
That's why I turned myself in.
and Your Honor, I told him, I want you to come to court, to the testing facility and test immediately. So he
Okay, what are
went
we
the next
doing today
morning.
on this case?
So, Your Honor, I am asking, and I just want to explain the THC also. He had smoked
What?
pot before he was arraigned, so it was still in his system. It's not any new usage, and the levels went down. I am asking that you.
But
could-
we don't know if the levels always went down because at some point he stopped testing. And I would know that his last test may have been masking because I have abnormal creatinine.
Your Honor, he will test going forward. He's had a very tough lesson of being not on his job for a whole week. He's in danger of losing his job until that you lost your job. All right, and until that point, he was doing everything the court ordered. I really do believe, as much as you doubt it, Your Honor, that he really did believe he did not have to test when he was coming in regularly and doing everything he was supposed to do. So I'm asking, Your Honor, that you release him and he'll be
He
testing.
has one like that? Why? Oh, okay.
Your Honor, he will be testing and he will not miss a single test and he will not have a positive test. And I am asking you, he's been in the jail for over a week. And I'm asking you, Your Honor, to please reinstate bond. He will do everything. I know it sounds doubtful, but he really did believe he didn't have to. He didn't do this intentionally. When I called him, he was shocked that he was still supposed to do this. So he legitimately did think he didn't have to.
I'm still trying to figure out what made him stop.
Your Honor, it was simply that misunderstanding of the form. It wasn't because I felt like I couldn't do it or that, that the test that went wrong, I simply was doing everything to a T, Your Honor.
And Your Honor, when I told him you have to immediately go in and test, he did. And they were just going to test him and let him go. He himself told them, I have a warrant for my arrest. He was very open and honest with them. He could have ended up coming in here that day and had this hearing. Instead, he was honest. They arrested him. He couldn't come in that day. It was too late.
If I reinstate his testing, will you stop?
Yes.
Anything from the people?
Your Honor, the people would like to be heard. When the defendant was arraigned, we actually asked for $150,000 surety bond. He was granted a PR bond.
When was this? The initial
The
arraignment?
initial arraignment. He was given a PR bond with testing, frankly, a gift. Obviously, he was unable to comply with that. But $150,000 was the request of our office. And the reason was this involved the defendant traveling under the influence of marijuana in excess of 100 miles an hour, broadsiding an innocent motorist in the city of Ypsilanti and killing that individual. So the defendant's claim that he's struggling with work is a far cry from the woman who was minding her business, driving and was killed. I think that $150,000 surety bond is a much more appropriate bond in this case, given the facts and the charges, than a PR bond with testing, which the defendant wasn't even able to comply with.
Your Honor, he showed up to every court date. He did everything he was supposed to do until this misunderstanding. He will do everything. He had no criminal record, has no criminal record to date. We dispute.
You're saying he turned himself in?
Yes, sir.
Yes.
At the corrections. I also took.
Well, no. So you didn't actually show up at the jail turning yourself in. You went to community corrections to resume your testing that you just unilaterally stopped.
Yes, sir. I said on the whim that she told me to take that as well.
And Your Honor, they were going to let him go and show up to court that afternoon, but he told them, I have a warrant. So they arrested him. So he was being open and honest. It's not like he was trying to abscond. Right after I told them about this.
I'm going to continue as bonded, no bond. I mean, I don't, unless you show me something else regarding that form, regarding that as to why he stopped, because he just stopped. And there's no reason. And in particular, given the nature of the case.
Your Honor, he had a good job. He was working. He would like to resume that.
What do you want me to do with the case?
Well, I would like to set it for another hearing, but I would hope that you would reconsider the no bond.
Yeah.
Can we have it, then can we set another court date, Your Honor?
Yes. But the 5th, well, actually, he's already set for the.
Okay, thank you, Your Honor.
What did we get on today?
When you saw him last week.
On the other thing, and that's how he's bad. Got it. Jail's done.
Yes, we only have one recall.
Who is that?
Mr. Aaron Konworski.
Is that Kaleem's case?
Yes, sir.
Yeah. Court calls the case, People versus Walter Lroy. Lroy? You take it any way you want.
Ready, Judge.
Yeah, Jonathan, on behalf of the people.
Court shall feature Assistant Public Defender, Mr. Walter Lroy. Mr. Lroy, please state your name for the record.
Walter Lroy.
Thank you, Judge. I have spoken to Mr. Edmonds about this case. It's going to do some further look at the matter to see where we stand in terms of an offer. We're asking just for an adjournment for a couple of weeks of the PCC. And then I need to address his, it's not a bond violation yet, I don't believe, but it's a bond report where Mr. Croy given permission to test in Genesee County. He signed up for a program, DNA testing in Genesee County. That program did not release testing results to the community corrections unless he was
Well, hold on a second. That's not what I have. Do you have his progress report?
The one that I have, I do have a progress report. I don't.
From August 28th?
I don't believe that's the date. Let me check.
Mr. Allen?
Yeah, mine dated August 28th.
In terms of his testing, I have on, so he's here on an operating while intoxicated causing death.
That's correct, Judge.
All right, and on August 20th, after his arraignment, what day was he arraigned?
I believe he was arraigned on the 16th.
So then he got tested on, yes, on the 16th he was ordered. He wanted to test there. He tested on August 20th And he's positive for cocaine.
Correct, Your Honor. I'm aware of that.
Then on the 22nd, he didn't appear for his testing.
That was when I was setting up to be tested in Genesee County. I didn't have to test again because I had just tested. I was just signing up to test in Genesee County. And I called the lady down here to let her know right away.
All right. Let's go back a moment because I don't think he's been before me.
I don't believe so, Judge. Just asking for a 2-week adjournment to see where we stand in terms of the potential.
Why is he testing positive for cocaine after getting charged and arraigned on an operating while intoxicated causing death?
Because he used cocaine, Your Honor. Obviously. I don't think he's.
No, it's a fair answer to my question. I'm just saying why.
Yes, Judge.
Why? I mean, why is he using anything?
Well, my understanding is he is not any longer.
What?
My understanding is he is not any longer, but he previously was. He began testing, transferred that testing to Genesee County per the instructions he was given at arraignment. He's been testing there, but they are not reporting the results here unless he is positive. They have not called him test this week. He's called them twice a day to go test. They have not called him, so he went over today to community corrections and tested here. And he is going to change if the court allows.
He tested here today?
Here this morning.
What is it? Do we have results on that?
I don't have it.
I don't have anything yet.
I was informed about it this morning myself.
So, go ahead, Mr. Green.
Thank you, Judge. So rather than do the Genesee County testing that authorized to do that does not send the reports as community correction would require, he has signed up again today to test here and do all of his testing here, although he does not live here. He has a relative here with him who has agreed to drive him back and forth. To do that testing, if he is allowed, Your Honor. I understand.
What was the intoxicant in the primary offense?
Cocaine.
So let me get this right. He's charged, I just want to make sure. So I have it clear in my head.
You do.
He was charged with operating while intoxicated causing death.
Yes, Your Honor.
The intoxicant in that charge is cocaine.
Yes, Your Honor.
He's in arraigned. So now he knows what he's charged with. He's told to go to community corrections. When he gets to community corrections, mind you, 4 days later,
He tests positive.
he tests positive for cocaine.
I had some at my house, which I disposed of.
In your nose or what?
I had it in a tray and I disposed of it.
You what?
I had it in a tray
And then
I
you
threw
just
it away.
smoked it.
I threw it away.
You threw it away? How's that work? Where did you throw it? It's gonna be a long conversation. Where did you throw it away?
There was a little bit left. I used
I
it,
know.
and I disposed of the tray.
You what?
I used it and then.
Oh, you
of the
used
tray.
it then. Okay, so
There was only a little bit.
it didn't stay on the tray.
Right.
And I disposed of the tray.
Yeah. Yeah. Okay, well.
And since then, I haven't touched it since.
What's that?
Okay, he probably stopped using because he's coming today. And yeah,
I'm printing them now.
you're printing them. Mm. I haven't touched that since. So somebody needs to answer for me, why was he using after being arraigned
I mean, obviously,
on this charge? And why was he using?
I don't.
I have my theory, Your Honor.
I don't think there's any answer.
Oh, darn.
Satisfy the court as to why.
And by the way, you're still using.
Honestly, I don't see how. I
Oh,
have-
really? Hold on.
I don't
But
know.
you know what? The thing I hate more than anything is when somebody lies to me.
Honestly, I'm not.
Okay. Well, just make sure that you, because it has to be in your system in order for you to test positive. And if you, if it's been fine.
Counsel, approach briefly. You want to see this? That's my copy, though. Yeah, this is the one he took today. No, not at all. We need all of this on the record.
And the last positive, 22nd to 7 days later.
Yeah. 7 days later. And a little bit he threw away. Okay. Go ahead, I'm sorry. I'm messing up your story.
Oh, I know. But all I've done is I've used it in the chair that I saw. I've used it. That was it. When it's second, well, no, I have not. Okay. Well, we'll tell them that, but you know, medically. I know. I want to do this. I want the truth. Okay.
To answer your previous question, Judge, why?
Oh, he's positive for cocaine.
Judge.
And so that we know.
Thank you, Judge. And to answer your previous question as to why he's still using after being arraigned.
Sure.
Clearly he has a problem, Your Honor. There's no answer I can give you that can justify use of cocaine after arraignment when it's an illegal. He doesn't have any type of special license to allow him to use cocaine, Judge. So clearly he has a problem. He is willing to fix that problem when you test him there. He is working and he did voluntarily come here today and take a test. So he's asking you to not say that.
No.
No, you have to stay.
Right, anything else?
All I can say, Your Honor. What me say?
He was telling you the truth. Okay. My cousin doesn't allow anything.
There's no way to put it in your food and drink.
It's possible. I have friends at my mother's house where I'm cousin's house to do work down there. Okay. Because I'm gonna eventually reside down at my cousin's house.
All right. So to the positive test, Your Honor, I have no explanation aside from what he already told you.
Which positive test?
The
first one or this one?
The first positive test. Your Honor.
Oh,
The
okay.
explanation he gave you is that he used it and then threw away the tray. After he was arraigned, after he was ordered not to use, have no explanation, Your Honor. He'll just ask for mercy from the court on that, and he is willing to get any treatment that the court would allow him to take place.
Because he can't follow the court's order. I don't know how he's gonna do treatment. And the other thing is, he doesn't test when he's supposed to test.
Yes, Judge.
So it seems to me I have two options. I could let him go and say, oh, well, best wishes. Or what I can allow him to do is go back out there, use some more cocaine and kill somebody else. I'll let you know. Not doing it.
Understood, Judge.
Defendant's bond is revoked. Defendant remanded to the Washington County Jail. I'll set his hearing September 12th, 2024, 9 a.m. for probable cause.
9/12?
9/12.
Thank you, Judge.
You're welcome. Court does call the case. People versus Jade Lathan.
Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lathan, who is approaching.
Your name, ma'am?
I'm J. Ruth Bay, the nationality of Moorish American, beneficiary of the Principal Jade Lathan, and I'm making this special appearance at District 15, Michigan Court of Law under threat, duress, and coercion. I'm asking the prosecutor to dismiss this case on the grounds that there is no injured party. Plus, I have the right to a speedy trial, and this is the 5th time I've made an appearance for this in the case of this case in the court of law since February 2024 for the arraignment since the arraignment when the Ann Arbor Police Department apprehended me unlawfully and kidnapped me, forcing me to take fingerprinting and a mugshot when I am not a criminal. Officers Morgan Parker, 15400, and AA Condolis, 02002, claimed I fit a so-called description and also violently attacked me and produced a false police report against my person. These officers falsely accused me of committing crimes that the tapes do not show me doing at all. These tapes do not show me doing at all any of the things that I'm being accused of, as I've never harmed another person in my life and certainly not an officer of the law. I have also not disturbed the peace, and I have on file with the public defender, Kenneth Overwater, right here to my left, a character letter from my former teacher proving that I've always been well-behaved, a well-behaved student, and have always gotten good grades and have no history of foul play or violence, which is still true to this day. My legal representation on the day of the arraignment on February 2024, who helped grant me my freedom on bond, has already stated on the record that I have no history of violent offenses, which is the truth. And I assume why I was granted my freedom from police custody. I would lastly like to say that on March 11, 2024, I was denied two main sources of evidence for my case via my personal FOIA request that would have easily shown my innocence. These two things are the mobile gas station cameras, and that will show the young boy already on the phone when I walked into the gas station. But either way, I was not at all acting out of the ordinary or belligerent. I was nothing but kind to everyone in that store. And I'm nothing but peaceful, and I'm saddened that I have been accused of behaviors that are not true. And I would like to exclaim that I'm a victim of a false 911 police call when I had no idea I only know that because of the police report that I got after the fact. I humbly ask both the prosecutor and the judge that this case be dismissed because I have school and I have church to attend, and my college studies have already began on August 26th at the community college. And I'm asking you to grant me my justice from this, taking up my time, because my time is very valuable to my community and I would once again like to motion to settle this case for full dismissal in a speedy manner, because this case has already been in default judgment since the date of March 7, 2024, and I yield.
All right, so that we know that the review of the court's file, I've heard everything that the defendant has said. Court's review of the file, that none of the requests to adjourn were at the request of the people. It was always at the request of the defense in terms of any delay in these proceedings. Secondly, I do not need a response from the people. If I consider that a motion to dismiss, that motion to dismiss is denied. Where do we need to go now, Mr. Overwater?
Just be asking for an adjournment of the probable cause conference.
Any objection from the people?
No, Your Honor, I have offered a misdemeanor offer of 1 count of attempt resisting obstructing the police. I'll leave that offer open to the next CCC.
September 19th, 2024, 9 a.m. In this matter, thank you.
Thank you, Your Honor.
And if I could take the letter back.
Court calls the case, People versus James Lawrence.
With Overwater Assistant Public Defender on behalf of Mr. Lawrence, but not with him.
Let's call the case. The People State of Michigan versus Ali Abakur.
Good afternoon again, Your Honor. Hassan Mahdi on behalf of Ali Abu is approaching. State your name for the record, please. Ali Abu Khadr.
Right.
Your Honor, well, at this time, we're going to be asking for a preliminary examination.
Okay, I will be more than happy to set a preliminary examination. Also, counsel, did you?
I did.
The modification of the bond. Deal with that.
Your Honor, I did.
Oh, you saw it, okay. Would everybody be ready on the 10th? Or you would?
May I check my calendar, Judge?
Sure.
Yes, Your Honor.
That'll work. Preliminary examination be in person. September 10th, 2024, 9 a.m. before Judge Burke.
Is that time going to change or that?
No, that time is firm, that 9 a.m. time.
Thank you, Your Honor.
As to bond.
Your Honor, I laid it out, I think, pretty clearly in the motion. At this point, we are requesting an increase in the defendant's bond based on his non-compliance with surrendering the weapons. I have had conversations with defense counsel between yesterday and today. He has assured me that there is no AR-15 in his possession or otherwise. However, there are other registered weapons to the defendant which have yet to be surrendered. We are in the process of facilitating to have those be surrendered. However, they have not yet been surrendered.
If I may, Your Honor.
Yeah, well, I just want to clarify one thing. He wasn't on the Wayne County matter. He was not arraigned
When the offense occurred.
when this offense occurred.
Correct. It went Wayne County case, the conduct.
Okay.
Washtenaw County case conduct, Wayne County case arraignment, Washtenaw County case arraignment.
Allegedly. Conduct allegedly.
Understood.
Thank you.
But I guess what I was trying to figure out, so the magistrate in setting the bond, you believe, took into account the Wayne County conditions.
I am not certain of that, Your Honor. I is not the one who handled that arraignment or wrote the bond. So I cannot attest to what was said on the record.
I can speak to that.
Go ahead.
So this court knows Wayne County not only put him on a tether, but also home confinement. And Wayne County, obviously, through all their cases, when somebody's charged with a felony, is not in possession of any firearms, which at that point, Mr. Abu was not in possession, and to this day has never been in possession of any firearms after the bond. Now, that being said, I take full accountability for, and when I say I'm saying counsel, for him not turning in those guns or gun or whatever's at the home that we said to the prosecutor they're at. But he is nowhere near that home. He has to be confined to his mother's house, which he's been since day one, since he's left. What I could tell the court is we had many issues with both Washtenaw and Wayne. Why? He has two tethers on his ankles, one on each ankle. And Washtenaw was not going to release him because they were concerned that a tether was going to be cut off, which inevitably, after Wayne County promised they wouldn't cut it off, ended up cutting it off.
Cutting off
the Washtenaw County tether.
Who did?
The Wayne County Sheriff's Department. So, but then they fixed the tether, and then eventually a day later, they released him with two tethers. So it was a big mess. We were trying to get him out. I had discussed with my client this rifle that was in, I believe, a lethality or one of the reports that the allegation that the victim said. He said he's not aware of that. He doesn't have that. I left it at that. It's my fault. Registered guns should have been turned over 24 hours after release. He didn't do that. We are not willing. We are going to do that. I've sent the email to the prosecutor, an email stating this is the address that they're at. If you want, Ann Arbor Police Department can come pick them up. We have no issues. We're at the court's mercy. We apologize. I know I'm talking too much, but I want you to know, Judge, it was very difficult getting him out. He definitely doesn't want to go back in. We agree he should have turned in the guns. I'm taking accountability. The guns will be turned over, or guns turned over to the Ann Arbor Police Department. Your Honor, he has not stepped foot outside of that home, other than today, actually, after he was released.
Where are the weapons?
At his sister's house in Detroit. He's confined to his mother's home in Dearborn. And another issue that this court should be aware of, this,
Hold it. So I thought he lived in Redford.
he lives in Detroit, which is next to Redford, correct?
Correct.
Okay, so it's
I
actually.
know that.
Well, no, I mean, it has a Detroit zip code.
Redford leases it to Detroit.
Okay, whatever. Redford leases it to Detroit, but anyway, so yes, it's Detroit address. 2 blocks away from that address, which currently the alleged victim actually stays at, his home in Detroit. 2 blocks away from that is his sister's home, right? He's nowhere near any of that, and he's all the way in Dearborn with his mother, where he's been since he's left the Wayne County Jail. And he's confined to that home. Now, I don't want to give you my opinion.
But hold on, I'm trying to figure out, why are the weapons at his sister's house?
Well, I can approach on that end. I don't want to say it on the record, but they were not taken to his sister's house during the Wayne County or Washtenaw County's, the Washtenaw County case. They were not taken. They're there, Judge. That's
okay.
They were there prior.
How many weapons are we talking?
1 or 2?
Two. Is that what you have when it comes back that there are 2 weapons? I mean, I realize there's the AR.
Information from Detective DeMille at Ann Arbor is that he has 2 registered pistols to him. We also noted that the victim noted to Ann Arbor police that he either had access to an AR-15 or had an AR-15 in his possession. Detective DeMille noted that you do not legally have to or required to register an AR-15. So the fact that it is not registered does not mean that he does not have one.
Your Honor, may I approach briefly?
Yes, you may.
Thank you.
I mean, well, before you do, so here's what I'm trying to figure out. Certainly there's that condition. There may have been delays in getting him out and all those other things. I'm trying to figure out, as we speak right now, why those weapons are not in the possession of AAPD. I mean, that's what I'm trying to figure out. And I appreciate you, counsel, taking responsibility for it. But certainly the sister, if that's where they are, could have gotten those weapons and turned them over to AAPD.
She could have. But I know where I guess I know where the court is going with this.
Oh, maybe, because I can change directions in a minute.
No, I get it. And they should have been. I don't know what to tell the court. They should have been turned over. The reality is it was a mishap, not just on, I don't want to blame him alone. It was on my end. We were more concerned about getting him out.
I understand what counsel's concern is in getting him out.
Yeah.
But the defendant knows he's not supposed to be, particularly given the nature of the charges, he's not supposed to be possessing any firearms.
Which he didn't.
Right. But he was also to turn those over. And I'm trying to figure out between the time of arraignment and as we sit here today, particularly given the fact that they're at this 3rd location, why Ann Arbor PD doesn't have those weapons now.
Now you're correct. They should have been. But what I want to indicate to her, this 3rd location, they've been at that location before he was arraigned, before the Wayne County arraignment. That's my point.
Okay. Sorry. My point is this.
They should.
At some point, counsel gets the motion. At some point,
yesterday,
you two are having some conversation. I'm trying to figure out, particularly if his liberty is in jeopardy, why I don't have those guns now.
Oh, I got the motion yesterday. I wasn't even aware of this. Honestly, just kind of slipped our mind about these guns, the bond that Magistrate Fink had put about the guns being turned over. My point is, as soon as Sister Counsel sent me the email, I called her, I sent her a follow-up email, talked to my client, actually sent her a follow-up email and told her, here's where the guns are. Can you have Ann Arbor Police Department go pick them up? And that was the last that we conversed about that.
That is all correct, but I will say I am concerned because counsel even noted on the record earlier that Wayne County also orders as a standard condition in all of their cases, no firearms.
No,
So
they,
that would be 2 cases where he's not in compliance.
well, I don't want to put words in my mouth. I did not say Wayne County does the same thing by saying you cannot be in possession of any firearms. Magistrate Fink actually went a step further and said you have to turn them over to Ann Arbor Police Department. Wayne County did not do that and did not ask for that, just for the record. And at that point, I didn't know he had any firearms anyway.
Okay. I want the guns. I mean, for me, that's the bottom line. I mean, I'm worried about this AR-15 issue, but it's probably more of a national phenomena that we got to kind of deal with in terms of that and the registration. So I get that, but the ones that are registered to him, I'm trying to figure out why they didn't travel with you guys or with somebody down here today to get them to Ann Arbor.
Well, Your Honor, that's another thing. And Madam Prosecutor, I guess we don't know each other, but I did come here this today early and I told her somebody would have dropped them off like before court. And then she had indicated to me she was going to confirm with the police department on whether they wanted to pick them up or I just have somebody come before we were even in front of you to drop them off. And that was the last we spoke.
And before court was after the morning docket started, so I have not had an opportunity.
To check.
Correct.
I mean, I had no problem. The email was sent yesterday, last night, if Ann Arbor Police Department wanted to pick up the guns. Your Honor, I will tell the court this. They will be
who? Okay.
They will be here today. I mean, they'll go straight to Ann Arbor Police Department right now. I'll call whoever family members can go pick them up and
I want the guns.
We're going to get the guns too.
Oh, I know.
Oh.
And so I need confirmation that those guns, that Ann Arbor will take them. Well, I know they will. That's not going to be a problem. If they show up at AAPD, they're going to take them.
Right.
So I need those guns here before he leaves here. If I don't have the guns, he's not leaving.
We'll do that now.
Okay, let's go do that. I'm going to pass the matter and let Ann Arbor know that they're on their way. You go call whoever you got to call. They got to get down here.
Got it. Thank you.
In recess. Oh, it'll be a short day. Oh, yeah, I get up. Okay, bye. Thanks, Alan.
2 hours later.
Court does call the case of the people versus Ali Abu
Coder.
Abu Coder. I'm trying to put the syllable in the wrong spot. Okay, counsel, state your appearance.
Good afternoon again, Your Honor. Hassan Hamadi on behalf of Ali Abu Koder. State your name, Mr.
Ali Abu Coder. All right.
Assistant Prosecuting Attorney Morgan Burroughs on behalf of the people.
Okay, and my understanding is we
don't have confirmation yet. What I will tell the court is the individual is at the Ann Arbor Police Department. I contacted the Ann Arbor Police Department to say, hey, this is the vehicle that the guns are in. That's
as far as you've got.
Yep.
I am awaiting confirmation, but as far as I know, they have arrived at Ann Arbor Police. They're facilitating the turnover now.
Okay, so let me ask this, how many guns came down? There was in fact an AR-15.
Yes, one AR-15 and one
Glock 19 or Glock 40, one of them.
Well,
I was told it was a Glock 19.
Well, I don't care what you're told. I guess what registered under from the prosecutor's position, I believe there's a Glock 40 that's registered under his name. And there was a 9mm, I believe.
There are two, according to Detective Jamil from Ann Arbor,
yes,
there are 2 weapons that are registered to the defendant. One is a Glock 40 that was registered to him March 20th of 2020. The second is a Caltech 9 model P11 That was registered to him on April 12th of 2006.
That makes sense, Your Honor, which is actually corroborates what my client had indicated. The 2006 weapon was forfeited to the Wayne County. He had, at that time, a while back, he had a CCW case where they took the weapon and he never got that back. And then the 40, he did tell me he purchased a gun during COVID, which makes sense, 2020, which is the 40. But there is an AR-15 that is also in the vehicle with the 40. So a pistol, which is the 40, as well as the AR-15 is what's getting turned over. It's which all he has. Do you have any other weapons?
No.
Okay.
But didn't you say there was another one that was registered to him?
The Caltech 9, which was registered to him in 2006.
Okay, so that's the one that you're saying was forfeited.
Correct.
Okay, so there should be a Glock and an AR-15 that are turned over.
That's correct.
Okay. All right, so that everybody doesn't have to wait for this, and then forfeited. AR-15 and Glock. Some specificity. So here's what we'll do is we don't have to all wait here for confirmation. Confirmation to come through. Madam Prosecutor, if there's a problem, let counsel know. And we would set something at 1 o'clock tomorrow if that happens via Zoom. So to try to get everything straight regarding that before this proceeds on next week or in a few days for a preliminary exam.
Understood.
Okay.
I would be an idiot to ask for this, but I feel like I feel like I was going to ask for this before this whole motion was filed. And I don't know if it makes sense. I already told my client, you're on home confinement in Wayne County, and then Washtenaw County put you on home confinement. I was going to ask Wayne County to take him off of home confinement, which I have not done yet, obviously. Your Honor, don't worry about it. I strike everything I said. I'm not going to ask for a bond issue right now, especially that the court has had mercy on us and kind enough to take care of us on the weapons. You have a wonderful day.
All right. And let me just say this. Sir, your attorney's a very good attorney. And he's the only one that saved you from being locked up. I need you to understand that.
Yes, sir.
Because he represented what you told him to this court, that there was no AR-15. And there happens to be one.
Yes, Your Honor.
And it's only through the eloquence of his argument that this court has shown you any grace to not lock you up tonight just for even making that or causing that misrepresentation to be made to me.
Thank you.
Don't thank me. You thank him. Because
Your Honor, and I do apologize.
I would.
I do apologize for that. We try to be as honest as human beings as possibly, but sometimes for many reasons, anyway. Thank you, Your Honor.
Thank you, sir. Okay, are we finally done? Really?
I mean, let's do more. I'll find something.
No, let's not. For the day. I'm good, Alan. You can keep everybody down. 14A stands adjourned. I'm good, though.
A stands adjourned. You know what that means? We're going to Houston, Texas. Ladies and gentlemen, we're rounding the corner. We've come to the last. Wait, what am I trying to say here? We saved the best for last, and it's Judge Fleischer. I'm just gonna play it because I'm not saying it.
Yeah. Hi, Ricardo. Approaching on a fugitive case, Mr. Bradley Mathis is in custody.
Oh, hey, I forgot. Let me just throw myself in here real quick. This Fleischer set features a suit from almost every day of the week. There is one case where we follow them from one day to another, but you'll see pretty much individual cases in this whole set. And yeah, it's a lot about the wardrobe here. And we have a special little feature from one of our community friends that I thought I'd like to share with everybody at the end. So that's what this set's all about. Let's do it.
So it looks like he's on bond for reckless driving in court 14. And that's what probably led him to him here.
That's correct, Judge.
What's he wanted for?
I'll let Amy go ahead and speak to
So
that.
they double confirmed with the domain jurisdiction. He's wanting for DUI causing death.
Judge,
And
actually,
he's driving like a maniac now. Can you bring him out, please?
the reason for the fugitive warrant is violation of a court order. Now, my understanding from speaking with him is he was arrested for a DWI. They took him to the hospital, drew blood, and they released him. So it sounds like this was a 2B warrant that hit, and he didn't have knowledge of it until he was arrested for this reckless driving.
Someone in a car.
I understand, Judge, but
What
he
are you
didn't.
doing with this reckless driving, if you don't mind me asking?
Project a couple of concepts.
Hold on, let's wait for him to get on, please.
Yes. He doesn't have it.
He doesn't have the immigration law. Okay.
Is this one?
Morning, Mr. Mathis.
Morning.
How's jail?
Miserable.
Good. Makes me very happy. Looks like you're wanted out of another jurisdiction for a DWI causing death.
Yes, sir.
And now we have you here because you picked up a reckless driving. You want me to let you out?
To go to Mississippi. Yes, sir.
It's cute. I don't even know what happened. Let's figure out what happened in the reckless driving.
Judging the reckless driving, on August 25th, 2024, officers were patrolling the southbound 600 blocks of East San Luis Tollway South. Officers observed the defendant in a black lifted truck traveling at a high rate of speed. The officers captured him speeding for radar at 97 miles per hour and 65 miles per hour zone at the 9200 block of San Houston tollway. As officers attempted to catch up to the vehicle, the officer observed the defendant cut across different lanes of the highway while failing to signal and cause other vehicles to brake. Officer observed the vehicle following other vehicles closely as it cut across.
Don't say anything specific, Judge. I would like to state that this case is out of court 14.
My concern is for public safety. He's already killed someone on the road with the DWI, allegedly, and now he's driving at near about 100 miles an hour, weaving in and out of traffic, causing others to brake around him. And you want me to set you a bond? Really? I would like hair. It's not gonna happen though, man. Not as my wildest dreams, as much hair as I want, I'm never gonna get it back. Perhaps I can get plugs, I guess, right?
Judge, if I may, Judge. Judge, so this is a fugitive case. The basis of the fugitive case is for him to answer in the demanding jurisdiction. He had no notice that this case was open. It sounds like the comparison here to Harris County would be a 2B warrant. Nobody notified him of a court date, a court setting. The actual charge is violation of a court order. So I'm assuming they want him to present
I don't know
himself.
that. How do you know that?
There has been no presentation made besides him having a fugitive case. If
How
that's the
long has this case been open, Amy?
Judge, I do not have that information at this time.
And that's the problem with these cases. We don't have the information. So just on the information we have, he's got a fugitive case, violation of a court order. I would ask for him to be allowed to answer for that. Is regarding public safety, he's answering for that in court 15. He's answering for that in Mississippi. This case is just to assure that he makes it to Mississippi to present himself, to avail himself to their requirements. He hasn't had the opportunity to do so. This is the first notice he's had from what he's telling me that he's had to present himself, and he's got a plan in place to do so. He hasn't messed up in your court before. I'm asking for the opportunity for him to go turn himself in. If he messes up, okay, fine. At that point, we have no answer for why he messed up. But right now he's saying he was just made aware of this when he got arrested for this. He wants to answer for it. I'm asking for the opportunity for him to do so.
Your Honor, if I may, I have a newborn son, and I'm trying to resolve all of this. Because I can't do this again. I don't need to do this.
Just did.
Yes, sir. I'm
just
talking about being away from him. I have
love and appreciate your tenacity, but I think that you are a complete danger to our streets. We lead here in Harris County, the nation per capita in fatalities related to drunk driving cases. We, if you watch the news, every single day have someone dying on our roads because of someone who is making a boneheaded decision to drive like a freaking maniac. And you, not only do you have this case, but you are charged with killing another in another state while being under
he
the
was
influence.
a very, very good friend of mine, Your Honor. And
specifics. Very people who use this.
So does that make it better?
No, sir, it makes it worse.
Right.
Judge, if I may, he is presumed innocent, Judge. He's answering for these charges. He's presumed innocent. The basis of your
not finding him guilty, but Ricardo, I think that he's an extreme danger to public society. He's a danger to our roads. And what we will do is I will hold you at no bond in our jail until you resolve these cases. And at that point, we will notify, or I mean, you've already notified Mississippi that we haven't, correct?
Yes, Judge.
Okay. Hey, Rick.
Judge, where he's got no other criminal history. When was this DWI?
Last year.
Last year.
May.
He's had no criminal history since this one DWI and this reckless driving. He hasn't answered for him yet. He's willing to answer for him. He's got no other criminal history besides this. We don't know the specifics of either case. I can't argue for him in either case because I don't know the specifics. He just needs to answer for
Ricardo, he's charged with killing another on the road and now he's driving at about 100 miles an hour. I'm not giving him a bond. You will have to wait to answer until Mississippi comes and gets you. They will take you back if they come, because I don't even know if they're going to come. If they don't come and get you at that point, you know, within the prescribed time, Harris County will release you. But me, I don't feel comfortable giving you a bond because I don't want that kind of blood on my hands. If I give you a bond and you go out there and do something, that's on me. And I have enough trouble sleeping at night as it is. I don't want that kind of blood on my hands.
Judge, can we do any other kind of conditions that you would find reasonable to?
I promise you, Your Honor. My
I know
son
that
is
you're
a
going
lot
to
more
promise
important
me
to
it's
than anything else.
gumdrops and tulips and little bunnies jumping in the woods, but I don't believe you.
His wife can drive him to me. We could sign a no driving affidavit if that's your concern. As long as it gets him out of jail, he will make efforts to get over there. He will sign a no driving affidavit if that's what it takes. Correct?
Absolutely. Yes, sir.
And he's got a plan in place. His wife will take him over there. He works at the refineries. I don't think money's going to be an issue for him. He's a welder, supervisor, something up there, inspector. And so he's got a plan in place. Holding him in jail for 14 days to wait for Mississippi is already punishing him for something that he hasn't been convicted of. He's got, we could find other alternatives to allow him to go over there. He could show you a bus ticket. He could.
I'm not giving him a bond card. I'm sorry. You're going to have to wait until Mississippi comes and gets you. And at that point, you can answer the charges, but I'm not letting you out. Sorry, just too much blood.
Understood, Judge. I'll talk to my client.
Duarte, come on up.
Okay.
Ready?
Yeah. All right. Good morning. You ready? Right.
Brown, come on up.
I love to sing at the moon and the June and the spring. Sing what's Vic, what page?
Brown is on page
Oh, Brown.
6.
Good morning, Ms. Brown. Ma'am, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On July 24th, 2024, officers were dispatched to an assault in progress. Officer spoke with the complainant who was a caregiver at a group home where the defendant is a client. The complainant stated that she asked defendant to shower to get ready for a daycare facility. The defendant began yelling and calling her all kinds of derogatory names. The defendant then started punching her in the face and bit down on her right thumb. The complainant stated the defendant began grinding her teeth on her thumb as the complainant's thumb was in the defendant's mouth, causing severe pain for approximately 1 minute. The complainant stated that she used her left hand to try to push the defendant's face back away from her as she attempted to pull her thumb out of the defendant's mouth at the same time. Defendant admitted to biting the complainant on her right thumb and stated that she tried to rip off the complainant's thumb when she bit her. The defendant further stated that the complainant assaulted her with her fist in the back of her head. The witnesses confirmed the defendant attacked the complainant by biting her on her hand and stated that she did not observe the complainant assault the defendant. The doctor, who was a plastic surgeon and hand specialist, stated that complainant had the bone on her right thumb bitten through and it would require surgery to repair along with possible rehab. The doctor was unable at the time to determine if there was ligament damage or if there would be a long-term loss of function or functionality to the appendage.
You're lucky you're not charged with aggravated assault, ma'am. Be facing up to 20 years in prison. How old are you? Ms. Brown, I'm going to find that there's probable cause to go forward with your case. Are you here with anyone today? Are you here with anyone today? How did you get here? Uber. Okay. This is what we're going to do, ma'am. I will appoint you a lawyer today. Are you still living in the same group home as this one, or did you get moved to another one? Okay. I'm going to tell you something that if you continue to fight and act like this, you're going to alienate every group home, and then you're going to end up on the street. If you end up on the street, you will do damn near anything just to survive, including giving yourself up, if you know what I mean. Life on the street is extremely rough. It's not fun, and it's dangerous. Who knows who you'll meet, what you'll do, how you'll end up. It's not good. Do you understand? So when you're in a group home, be nice. It's not hard. And if you get upset, aggravated, find another release. But if I find that you start acting like this again, I will put you in jail. You need to understand that you don't have anyone that's going to bond you out. So if I put you in jail, even at $100 bond, you don't have anyone that's going to make it, and you'll be stuck like Chuck in there until this thing is over with, which would be the better part of a year. Do you understand? Okay. For now, I'm going to have you sign a reset with Victoria. Then I'm going to have you take a seat. I'm going to find you a lawyer, and then we'll figure out where we go from here. Okay? Please. So,
Judge, does she need the financial?
no.
Yes, Judge.
Can you go ahead and file no going back to that group home, no contact with complaining witness, no assaultive or combative behavior, no weapons, and then we'll have her sign it momentarily.
All right, Judge, page 11, Gilbert. He's the one that came up yesterday, Judge. I don't know if you wanted to do bond conditions and all that.
Did we do a test? For everything. Okay. Did you want me to appoint you a lawyer today? Okay, so we will do that. I am ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, then I'm going to put you in jail. I am going to give you a handheld device that you're going to take with you everywhere you go to prove to me that you're not consuming. Do you understand? I know that you have a problem, and so I'm going to make sure that you're not consuming. And if you do, we'll just put you in jail. I have way too much drama in my life. I don't need any more. Do you understand? Okay. I'm going to have you sign a receipt with Victoria, then we'll just have you take a seat in the jury box while I find you someone, and then we'll have you speak to them here momentarily. That way. Rachel, can you waive the fee, please? Domino's Pizza. Oh, damn it. Did I say that? Okay. You want Wednesday, or what days do you want? Okay, done. All right.
Correct.
Ah, Lord, have mercy. Hey.
Got a few things. I think we can start with Mr. Samuel Garcia. He just showed me right when he signed up for the GED classes.
What's the last name?
Garcia.
Which Garcia?
Your honors, it would be Samuel.
Come up, Samuel Garcia. It's not a good morning. You continue to test positive for marijuana.
Nah, that was from.
No. I just sent you for a test and you test positive, and I told you I was going to test you after 30 days. And if you continue to test positive, what was going to happen? That's exactly right. So guess what happens now? I don't.
From my last court date.
You tested positive again. It's been over 30 days, man. I'm sorry, John D. He knows.
All right, I'll be back.
What's with you? I'm sorry, John D. So let's do this. He'll auto-populate again tomorrow. Let's set off just a couple days and then.
Just FYI, he's got to defer off right tomorrow. Offers. And he did have proof that he signed up for a GED class that starts September 3rd, 4 days a week.
Okay.
for 3.
All right.
That's what
I want him to start it by then. We'll yeah.
Okay.
Josh. Okay. Where is she? Miss Brown, come up. Are you taking any medication, man? What do you take? Guys, keep it down, please. Do you take 1, 2? How many do you take? Take 10. Wow. What happens when you don't? You know, it seems to me that when you take it, good things happen, right? That's the idea, right? Because what happens a lot of times when people take medication like this, they start feeling good. They come to the conclusion, hey, I don't need this anymore. I feel great. You know, everything's going well. I don't need it anymore. They stop taking it and things spiral out of control again. That's the wrong thing to do. Just keep taking it. When this happened, had you missed a dose? Okay, you can't. I am now making that also as a condition of your bond, that you must take all prescribed medication. And if you don't, then it will give us cause to revoke your bond and put you in jail. And then we'll administer the medication in jail. So we can do this the easy way, or we can do this the hard way. That depends on you. What else are you doing with your life? Are you in high school? Wonderful. What's going to happen with your life now? That's great. Have you applied? Are you in, or what's going on with that?
Kind of find out where she's gonna be at, starting the process.
Are you allowed to work? Do you have a job? Perhaps you should do something. You know, when you have too much time on your hands, self-destructive things start happening. It's good to either, you know, have a job, get in school, something that get your brain to move and to think and get yourself to do things. You know, it occupies your time, you learn, and you might even make some money from it. So you need to find something to do, but just besides sit and vegetate at home. When is the last time you were in school? So did you just graduate from high school? Great. Okay. We need to make a plan on how to move forward. You need something to do with your life. I think school's great. The more school you do, the better your life's going to be. You'll earn more. You'll have more knowledge. That's the way that's what you should do, in my opinion. Now, you don't have to do it. You know, perhaps get a job, but something has to happen. I'm going to set your case off a couple of weeks. I want you to contemplate and think about what you want to do these next couple years of your life. Do you want to go to school, or do you want to get a job? But I want you to find something to do, not just sit in the home and do nothing. That's not productive. When you come back here in a couple of weeks, I want to know what you're doing and what plan that you've set in motion. If you haven't done anything, then you and I are going to create a plan by ourselves of what to do. Do you understand? Okay, you've got 2 weeks. I want you back here in 2 weeks, and I want to see that you're continuing to take your medication. Do you have any questions? Okay, once you get on the straight and arrow, and that I know you're being productive, I will start waiving your appearance little by little, so you don't have to come to court. But up to get to that point, I need to know that you're doing something with your life and not just sitting in a couch watching TV all day. All right? Okay, we'll see you in a couple weeks. Thanks, Josh. She must sign conditions before she's allowed to leave them. Hi, Ray. Okay. Sorry, I'm just writing this down so I don't forget. So your client, what's his last name?
Malone.
Come up, Mr. Malone.
So he's still waiting to approach upstairs, Judge. They're in trial, which is what.
I understand. So on Mr. Malone, do we have a bond violation?
Yes, Judge. Alleged curfew violations. There's several on there, but then there's a few that indicate that the pretrial officer reviewed them and determined that he was home. Maybe he like stepped outside of the residence or something to that effect. There's a few where he's like
stepping out. You step outside, then that's the wrong thing. I'm putting you in jail if you do that.
I can't walk around my apartment.
No, home confinement is home confinement. Rachel, tell me about Mr. Malone, please.
There's others where he was like he was about 30 minutes late. It's a 7 p.m. to 7 a.m. He was like 30 minutes late.
I have a problem with that.
Then there's a couple where he had to leave. Like one of them, I think his sister's car broke down. He went out to go help the sister.
How do I know that?
We understand, Judge.
I don't care what you're doing. You have conditions for a reason, Mr. Malone. Tell me, Rachel, please.
There is a lot of dates, and the officer they put that they determined that he wasn't at home, but I'm assuming that he was on inside. So like, for example.
Well, they said one, he went out to go fix the sister's car, allegedly.
Like, for example, on 7/27, he left at 5:54. He returned back home at 6:32 and then left again. But then it says that it was researched and it's determined that he was at home. So that just means he's going outside or going somewhere in the apartment. Another one, 7/28, left at 19:48, which is
7:47.
48, returned at 20:14.
Oh, goodness, that far off?
30 minutes.
No. She said 19. That's 2 hours.
No,
She
19
said
to 20 is 30 minutes. 1948 to 20.
the time, Rachel?
1948 to 2014.
Yeah, that's
Okay.
less than 30 minutes. It's
But then there's
26
one
minutes.
that
Listen,
was 24, left at 2014, returned at 22:13. But
Mr.
again,
Malone, I'm revoking your bond. It goes with you. You've gone for 2 hours on that one.
If I may, can we hold off on that for a moment? The reason I say that is because upstairs, they're offering him a time served, which Mr. Malone is more likely going to take. If he does that, the state's going to dismiss this case here.
Okay, I'll do this to you. I'll roll it to tomorrow and I'll set up for bond forfeiture. You must be back here tomorrow. If you haven't taken the case, if you haven't taken care of it, you're to be here tomorrow. Do you understand?
Yes, sir.
And when I mean stay at home, stay at home. Don't go out. Do you understand?
Yes, sir.
I'm gonna see you tomorrow, one way or the other. If you don't take care of it upstairs, I'm taking care of you tomorrow.
Yes, sir.
All right?
Thank you, Judge.
Next is page 3, Armendariz Lemont.
Miss, Amendares Limon. Ma'am, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you cannot afford a lawyer, ma'am, a lawyer will be appointed to represent you. Okay.
On August 23rd, 2024, in Harris County, Texas, defendant was riding in the car when her boyfriend was driving, and officers conducted a traffic stop. Defendant's boyfriend again was driving, and the defendant was in the passenger seat. Officer observed the car to have expired registration. The defendant's boyfriend stated to officer that the car belonged to the defendant. The officer ID'd the boyfriend and discovered that the information on his license did not match the system. Defendant's boyfriend fled the scene and officers pursued him. A second officer tried to speak with the defendant, but she had fled the scene as well. Officer was able to identify the defendant based on prior stop by another officer 6 days prior for a defective headlight and driving without a license. Also, officer identified the defendant's name in the system and found contact information for her mom, where the defendant's mom verified the defendant's name and her boyfriend.
So where's the interference? What did she do?
I'm assuming she fled the scene.
What? Okay, read to me exactly what. I didn't hear what she did wrong.
So it just says that they stopped her. Her boyfriend was driving the car. The car had expired registration.
Okay.
And so they asked for his identification.
So he's driving.
He was driving.
She's in the passenger seat.
Yes.
So they stop, ask for his information. He bolts.
Yes.
What did she do wrong?
She also left. She left the scene as well. She left the scene.
Huh. And they charge with interference as opposed to evading arrest?
They didn't give her a lawful order to stop because they were first pursuing the driver. So he would be charged with evading had they caught him. But she was not ordered to stop because she evaded while the other person was already evading.
How did she interfere? It's interesting the charge they're trying to get to, but she left. How's that interfering? If she's not ordered to stop, then she's free to go. If she's under arrest, if she's not, she's free to leave unless the officer tells her, right? I mean, walking while Mexico. No, I'm gonna find no probable cause, man. But I'm gonna tell you, this is your second case here within the last year. If you want to drive and get a license, and be careful with the company you keep, it's very possible that, when you hang with dogs, what happens? You get fleas. This is the second time here. Make wise choices. I'll just have you take a seat in the back, okay? Please. Thank you, man.
This one?
He wasn't here.
Well, he's here now, but they're taking a trial date. So I'm like, what, are you skipping your part?
What?
Yeah.
No, I need to talk to.
Okay.
Brent, come on out.
I thought so. I think they're trying to avoid you.
No, are you taking over for Mr. DeGuider?
He's gonna be with me, but
You want to set up for trial?
Yes.
So I put him in jail because he violated bond conditions. He just filed back out.
Okay.
That felony he picked up a long time ago.
Correct.
Unless he picked up a new one.
Yeah.
No, that one he picked up like 2 months after this case, but
Okay.
now there are bond violations, so he's going out. Mind having him come up, I'm gonna have him the same bond conditions, and I'm gonna tell him next time you muck up, it's gonna be $30,000. Get him, because I'm really gonna tell him about it. No, I'm not gonna take it out. No, but I'm gonna tell him, you don't like it? I'm happy that you don't like it. Stop picking crap up. You know what I mean? Please. Thanks, Frank.
It's on page 9.
I'm sorry. Is the ankle monitor annoying you? Stop picking up cases, man. That's when we take it off. Stop violating bond conditions. Then we take it off. Mr. Green, the monitor will remain on your ankle. The conditions that you had last time will remain in place now. And if you violate the condition this time, I will triple, if not quadruple your bond next time. At some point, someone is going to stop ponying the money up for you to get you out. As it stands now, so you want to set the case for trial?
Yes, Your Honor.
Mr. Green, I'm going to tell you that today is your plea deadline. If you want to set this case for trial, I'm happy to do it. What offers do you have on the table now, guys? Now, is that the only thing that you have offered now? Okay, they've offered you time served on this case, meaning that if you were to plead, you walk out of here, we're done today. Today's the last day for you to do that, though. You can either accept it or reject it. If you reject it, that's fine. We will set your case for trial, but I'm going to tell you, once you set this case for trial, I will not take any more plea bargain offers. I will not take any, I want to plead guilty, they didn't get this done. No. Once we set this, you will be put to trial. Do you understand? I'm not having, you don't need to make the decision now in front of us. Just go outside, talk with Brent, tell me what you want to do. If you want to set it, we're happy to do it. We've given you a trial date now. I expect you to live up to the bond conditions. And that's it, but no more offers after this.
Your Honor, I can tell you, we spoke for about an hour last night. It's a guilt innocence thing. He does not want to plead guilty.
Okay, that's fine. Are you sure? Just because I want you to know that once we set it, no going back. Okay, all right, Brent. Thanks, guys. Yes, but Mr. Green has in the need to stay to sign bond conditions with Rachel to redo it because he just got out of jail. And then after that, he'll be free to go.
Thank you, Judge.
All right, Mr. Green.
Mr. Strong, right this way, Green.
John D.
Judge, we have a plea for Mr. Samuel Garza. Can I bring Mr. Garza up?
Sure.
Garcia, I'm sorry. My bad.
You know, the idea that we have you here, Mr. Garcia, is that we get you to do some good in your life, to, at the very minimum, get your GED. While we have control over you, we can make sure that that gets done. Now you're just going to end up pleading guilty. All you're doing is you're taking more convictions. You're now working on your 6th conviction. You still have no GED, going nowhere in life but down. Is that a good way to go?
No, sir, I learned my lesson yesterday.
You think I believe that? Really?
Sir, that's why I came out, just to finish my GED.
Judge, just the other day, he did show me proof that he's actually enrolled at a class. He was scheduled, but now he has to get it rescheduled. But it's a 2-week GED program. He had the paperwork, and so he is on his way.
I start September 3rd.
I notate everything that we do here because it's impossible for me with the 2,500 children I have floating around here. I'm like the woman in the shoe, right? I have so many kids, don't know what to do. I write everything down. And with you, I'm writing everything down now. You're telling me you've changed your ways. If I see you back here, you will be nothing but a minimum of 90 days.
Sir.
Going forward. Do you understand? So you pick up a new case, you get into a car and drive without a license. If I see you back here, I will bring the pain. Do you understand?
Yes, Your Honor.
This is your third marijuana case. If you want to smoke, go to California. There are other places that you can smoke weed free and clear, just like little bunnies jumping in the woods. Not in Texas.
Yes, Your Honor.
And if you keep doing it, you're going to end up back here. And I'm telling you, it'll be a minimum of 90 going forward. Do you understand?
Yes, Your Honor.
I will do everything in my power to protect everyone in Houston. If that means putting you in there, I'm happy to do it. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Do you understand?
Sir.
What kind of credits, homeboy? 3 days in jail.
4 days credit, Judge.
Credit for the 4 days that you've done. How do you plead to the offense of possession of marijuana?
Guilty.
I will find you guilty. I will send it you to the agreement. Miss John D, he was going to be required to pay court costs. I'm going to make him pay it. You don't pay it, you will be doing 1 day in jail for every $100 that you owe. Do you understand?
Sir.
Okay, good luck to you, sir. Please see the clerk. Hi, Hugh. Good morning.
I have Todd Miller.
Is this the person that wasn't here yesterday?
Yes, well, yeah, we didn't have a.
Is he here now?
Yes, he's here. He's in the jury box.
Come up, Mr. Miller. Just same bond conditions as before. Just green. Yeah, he just got out of jail because he had a BVR. So we put him in jail. We just bonded out. Just want to redo everything that it was for. There was a curfew. I just don't remember off the top of my head. Just the same thing, whatever it was. I'm not happy with you. Mr. Miller.
Order in the court.
You are on probation, on felony probation for credit card abuse. While you're on probation, you picked up an assault with us. This is Todd Anthony Miller, right?
Yes, were you on probation? Yeah, he was not on probation. He was on bond for assault.
Showing he's on, oh, no, he's on deferred for credit card abuse, right? Todd Miller? Oh, maybe, unless he got early terminated. Oh, yeah, it looks like they early terminated.
Yeah.
Yeah.
Show that it's terminated.
Regardless, you're on bond for an assault, bodily injury, and now you've picked up an assault of a peace officer, a felony case. What happened on that case, please?
So on July 9, 2024, officers were dispatched to a restaurant in Harris County, Texas, in regards to an assault.
No, not on our case, on the felony case.
Order in the court, please.
Oh, you're referring to the assault, the security officer. My apologies.
That's okay.
Officer was dispatched to the Tipsy Lounge Bar located at 4806 Alameda Road in Houston, Texas, Harris County, Texas, regarding an assault that occurred. Officer spoke with the complainant, who stated that he is a licensed security officer, and while working at this bar, the defendant assaulted him. The officer observed the complainant wearing a ballistic vest, a gun belt with a firearm in a holster, as well as.
Say that again?
The officer observed the complainant wearing the vest, a gun belt with a firearm in a holster, as well as a highly visible gold badge that was around his neck in plain view, with the words "Personal Protection Officer" written on it. The complainant stated that while he was working security at the Tipsy Lounge Bar, he observed the defendant approach him in an attempt to enter the bar. The complainant observed the defendant to be highly intoxicated, so he denied him access into the bar. The complainant stated that the defendant began to bother the other patrons that were leaving the bar, so he told him that he needed to leave the location. To which the defendant became very hostile and took a stance as if he were about to fight him. Then the complainant began to escort him away from the property, and the defendant punched him in the chest with a closed fist, causing pain.
What did I ask you to do? When you picked up this case, what did I tell you to do? What did I tell you not to do? Right. And what'd you do? What happens now? Yes. He goes with you. No. I want my city protected. You out there, that doesn't happen. I'm revoking your bond. Yeah, so 5,002. Yeah. Sorry, Dean. Oh, but you know, did you guys watch the thing that Citizen Z did, animation?
I did. Thanks, Citizen Z.
I want to somehow put it at the end so that everybody can hear it.
Oh,
I wish I was so tech savvy, man. God dog it.
just practice over the weekend. You have a long weekend to practice.
In a quiet little office where justice reigns so high, there's a quirky Judge Fleischer with a sparkle in his eye, with a gavel on the desk and papers in a mess. He reaches for his Skittles, his moment of sweet rest. Oh, the Skittle caper's on, what a colorful spree. Judge Fleischer's in pursuit, it's a chase you gotta see. Through the courtroom, past the attorneys and the jury box too. He's chasing down those Skittles with a grin so true. But then a shadow creeps in, oh what a sneaky plan. Victoria in disguise, with a hat and clever hands. A quick little swipe, and the Skittles are gone. Judge Fleischer's wide-eyed, where did he go wrong? Oh, the Skittle caper's on, oh, what a colorful spree. Judge Fleischer's in pursuit, it's a chase you gotta see. Through the courtroom, past the attorneys and the jury box too. He's chasing down those Skittles with a grin so true. In an alley painted bright, they finally meet. Fleischer points a finger, but Victoria's got the treat. Stop or be stuck, like Chucky shouts with flair. But she throws the Skittles high, a rainbow fills the air. Oh, the Skittle caper's on, oh, what a colorful spree. Judge Fleischer's in pursuit, it's a chase you gotta see. Through the twists and the turns and the laughter so free, they share those Skittles in sweet harmony. Back in the office, the battle's all done. Judge Fleischer and Victoria sharing candy, having fun. With smiles all around, with little bunnies jumping in the woods. The Skittle caper ends just like it should.
And now you know why there's a caricature in the thumbnail. All credit goes to Citizen Z on the song and all the good stuff. There is a link in the description going to the Citizen Z actual video. If you would go there, give them a view, give them a like, give them a subscribe, all that good stuff. You just can't beat that type of effort. That's really cool. I do have a little bit of an announcement before we get things wrapped up here. Next week, I'm changing things up a little bit. I do want to apologize. I have a little bit of an engagement to be at during the noon hour, so I'm going to go live early next week. We're going to go live an hour earlier. So it will be, what would that be? 11 a.m. Eastern Time, 10 a.m. Central Time? Yeah? So, yeah, I encourage everybody to come out a little earlier. That's what we're going to be doing. We're going to be doing the same thing that we do right now and every other day that we watch court cases together. We'll be watching court cases. I'll find something, I'll curate it together, and we'll do the thing. But full disclosure, Next week is my 50th birthday, so the engagement I have to be at is actually technically my own birthday party. So yeah, I'm kind of required to be there. It's one of those things. Yeah, it'll be fun. I'm looking forward to it. It's gonna be great. But yeah, I think that's where we are right now. Hang out for a few minutes. We're gonna be what's it called? Redirecting over to Colin. I do believe Colin's going live next. So if you want more court content for your Saturday, stick around. There's more court content to come. Thank you all for the early birthday wishes. And yeah, I am a mere child. This is true. I am but a mere child. I refuse to acknowledge the XP gains, and I only behave as a child. That's my thing. But more than anything else, I enjoy spending my Saturdays with you guys. I enjoy spending my Mondays with you guys. So if you want some Judge Manning, do come by Monday, 7 p.m. Central Standard Time, 8 p.m. Eastern Time. I will have some Manning Monday. And yeah. What am I doing? Oh, there it is. There it is. A little hot. Coming in a little hot with the music. So what do y'all think? I hope I'll see everybody early. Because I really, my birthday lunch sounds amazing. I'm actually looking forward to it. It's going to be awesome. So, yeah, Colin. 2 or 3 minutes. Colin. We're going to talk here a little bit. I'm going to say good afternoon to everybody. I hope everybody has a great day. I'm going to try this whole vamp thing out. Thank you to Dreams for helping out as always. More than anything, thank you all for coming and hanging out with me. Without people to come watch the content, there's really... Well, I'll be honest with you. Even if nobody showed up, I'd be streaming for Dreams and Mom. I'd do it for 2 people and myself because it's just fun. But we will be back on Monday for Manning. Be here. If you're not here to watch Manning on Monday, you're square. You're square. That's just all there is to it. We're getting out of here. Time for Colin. Ladies and gentlemen, thank you very much. Y'all have a great day. I love you all. You're all wonderful. I can't say thank you enough. It's just not possible. L7 Mortimer. I wish I were a beer. I will never not be grateful, Kai. Thank you. You don't have to thank me. Thank you. Without you people, I am nothing. I'm nothing. Peace out. See you, Collins. Later.